"This isn't a mock trial," Vane said, loud enough for the hallway to hear. "And that suit tells me you're more used to a kitchen than a courtroom. Why don't you take the settlement and go buy yourself something nicer?" The linoleum floors of the county courthouse were scuffed and dull, reflecting the fluorescent glare like a warning. Outside courtroom 3, a black woman sat alone on a hard wooden bench, silver-rimmed glasses balanced neatly on her nose, a stack of loan documents spread across her lap with the quiet precision of someone who'd read Payne for a living. Her suit was navy. Slightly loose at the shoulders. Clearly thrifted. $15 at a Goodwill 2 towns over. She'd chosen it deliberately. Around her, corporate attorneys in $3,000 Italian wool drifted past like they owned the building, polished shoes, easy laughter, the smell of expensive cologne and certainty. None of them looked twice at her. In their world, small claims court was where powerless people came to lose quietly. Vane noticed her only because he found her funny. He stood by the courtroom doors with 2 junior associates holding tablets, nodding like dashboard ornaments at every word he said. When his eyes landed on the $15 suit and the worn briefcase at her feet, he smiled, the kind of smile that didn't carry warmth. "Is she serious?" he muttered, then raised his voice again. "Legalese isn't for everyone, sweetheart." A few people in the hallway laughed. Not because it was clever, because it was safe. The black woman didn't flinch. She didn't argue. She didn't defend herself. She simply wrote one more note in the margin of the contract, slow and deliberate, as if she had all the time in the world. Johnson leaned closer, enjoying himself now. "You're out of your depth with big boy contracts. Take the deal. Save yourself the embarrassment." That was the moment he made the mistake that would end him. Because Vane didn't know the woman he was mocking had once been the state attorney general. He didn't know she had personally authored the consumer protection statute his firm had been violating for years. And he didn't know that while he was performing for the hallway, she was quietly building a case big enough to collapse his entire career. Nia Williams turned another page, calm as a judge. Then the bailiff opened the courtroom door. And Vane walked in first, smiling, certain that today would be easy. He was catastrophically wrong. 3 weeks earlier, a $500 loan had put a family one signature away from losing their home. Nia had met Shanice Porter in a church basement that doubled as a legal aid clinic every Tuesday night. Shanice was 28 years old. She worked 2 jobs, one at a grocery store, one cleaning offices after midnight. She had a 6-year-old daughter named Kaya who was supposed to start 1st grade in 3 weeks. But none of that mattered anymore, because Shanice was being evicted. "I just needed $500, Shanice said, her voice quiet and tired. "My car broke down. I couldn't get to work without it. So I took out a loan." Nia nodded, her pen ready. "When was this?" 8 months ago. Nia looked up. "And how much do they say you owe now?" Shanice's hands shook as she slid a paper across the folding table. $2,400. Nia read the document slowly. It was a loan agreement from Pinnacle Recovery Solutions, the largest debt collection firm in the state. The interest rate was listed as 12%, which sounded reasonable. But buried halfway down the second page, in letters so small they were almost invisible, was a section labeled Account Maintenance and Liquidation Fees. Nia's jaw tightened. "They've been charging you a fee every time you made a payment," Nia said. "And another fee every time you missed one. And another fee just for having the account open." Shanice stared at her. "Is that legal?" "No," Nia said. "It's not." Shanice's eyes filled with tears, but she didn't cry. She just sat there, holding the eviction notice like it was something fragile that might break apart in her hands. "Can you help me?" she asked. Nia closed the file and looked at her directly. "Yes," she said. "I can." Vane didn't whisper when he wanted to insult someone. He projected. "Look at this," he said, loud enough that the bailiff by the courtroom door turned to look. "Small claims are really scraping the bottom of the barrel today." His associates laughed on cue. One of them, a young man with gelled hair and a phone in each hand, glanced at Nia and smirked. "Is she even a real lawyer?" he asked. "Probably a paralegal," Johnson said. "Or someone's cousin who watched a YouTube video and thought, hey, I can do that." More laughter. A few people in the hallway looked over. Some smiled. Some looked uncomfortable but said nothing. Nia turned another page in her file. Her face showed nothing. Johnson stepped closer, his shoes clicking on the tile. He stopped about 10 feet away, close enough to make sure she could hear him clearly. "That suit," he said, shaking his head slowly. "Did you borrow that from your grandmother? Or did Goodwill have a half-off sale?" The associates laughed harder now. One of them actually slapped Johnson on the shoulder like he'd just told the funniest joke of the year. "This isn't a mock trial, sweetheart," Johnson continued, his voice dripping with fake concern. "You're going to embarrass yourself in there. Why don't you take the settlement we offered and go buy yourself something nicer? Maybe something that fits." Nia finally looked up. She met his eyes for just a moment. Her expression was calm, almost kind. Like she was looking at a child who didn't know any better. Then she looked back down at her paperwork and made another note in the margin. Johnson frowned. He wasn't used to being ignored. "Your funeral," he muttered, turning back toward his team. Nia's pen kept moving, steady and sure. Nia owned 7 suits. 4 of them were tailored, expensive, the kind you wore when you needed people to take you seriously the moment you walked into a room. She'd worn them during her years as state attorney general, standing in front of cameras and congressional panels and courtrooms filled with people who watched every word. But she wasn't the attorney general anymore. She'd left that office 2 years ago, walking away from the power and the spotlight and the salary that came with it. She'd left because she realized something important: the system protected people who already had protection. The people who needed help the most never saw the inside of those big courtrooms. Now she works in church basements and community centers. She took cases no one else wanted. She charged nothing. And she dressed the part. The $15 suit wasn't an accident. It wasn't about saving money. Nia had chosen it the same way a hunter chooses camouflage. When people saw the cheap fabric and the loose fit, they made assumptions. They thought she was inexperienced. They thought she was struggling. They thought she didn't know what she was doing. And that's exactly when they got careless. Careless people made mistakes. They said things they shouldn't say. They got overconfident. They stopped preparing. They underestimated their opponent so badly that by the time they realized their error, it was already too late. Nia had learned this lesson a long time ago: power wasn't always about looking powerful. Sometimes the most dangerous person in the room was the one nobody noticed. She closed her file and stood up as the bailiff opened the courtroom door. Johnson Vane was still laughing with his associates, his back turned to her. He had no idea what was about to happen. Nia walked into the courtroom quietly, her $15 suit hanging loose on her shoulders. She was exactly where she needed to be. Johnson Vane moved through the courtroom like he owned it. He nodded at the judge, a tired-looking man named Harold Brennan who had been assigned to small claims for the last 11 years. Johnson had appeared before him at least 40 times. They weren't exactly friends, but they understood each other. Brennan liked cases that moved quickly. Johnson specialized in making that happen. "Your Honor," Johnson began, his voice smooth and practiced. "This is a straightforward breach of contract case. My client, Pinnacle Recovery Solutions, extended a loan to Ms. Porter in good faith. She signed the agreement. She failed to make the required payments. We are simply here to collect what is legally owed." He placed a thick document on the table in front of him, the pages crisp and perfectly organized. "The contract is standard," he continued. "Fully compliant with state lending laws. Interest rate clearly disclosed. Payment schedule outlined on page 3. Ms. Porter had every opportunity to read and understand what she was signing. Judge Brennan glanced at the document, then at Shanice, who sat quietly beside Nia at the other table. Shanice looked small in the wooden chair, her hands folded in her lap. "And the amount owed?" Brennan asked. $2,417, Johnson said without hesitation. "Plus court costs and attorney fees, naturally." He said it like it was nothing. Like $2,400 was pocket change. Like Shanice wasn't about to lose her home over it. "Your Honor, this is not a complicated matter," Johnson added, spreading his hands in a gesture of reasonableness. "The defendant borrowed money. The defendant didn't pay it back. That's the beginning, middle, and end of this story. He sat down, confident and relaxed. Judge Brennan looked toward Nia. "Counselor," he said. "Your response." Nia stood slowly, adjusting her thin glasses. Nia opened her mouth to speak, but Johnson cut her off before she could finish her first sentence. "Your Honor, with all due respect," he said, standing up again with an exaggerated sigh. "I don't think opposing counsel understands how contract law works." Judge Brennan frowned slightly but said nothing. Johnson turned toward Nia, his expression a mix of pity and amusement. "You're going to argue that the fees are excessive, right? That's your big strategy." Nia met his eyes but didn't answer. "Let me save you some time," Johnson continued, speaking slowly like he was talking to a child. "Contract law is very simple. If you sign an agreement, you are bound by its terms. Your client signed this contract. She agreed to the fees. She agreed to the interest. She agreed to everything." He picked up the contract and held it in the air like evidence in a murder trial. "This is called freedom of contract," he said. "It's a basic principle of American law. Maybe they didn't cover that in whatever online course you took." One of his associates snickered from the back row. Judge Brennan shifted in his seat, uncomfortable but still silent. "Furthermore," Johnson went on, his voice growing louder and more confident, "there is no provision in state law that limits administrative fees on private loans. None. If you had actually read the statutes, which I'm guessing you haven't, you would know that." He turned back to the judge. "Your Honor, I move that we proceed directly to judgment." Opposing counsel clearly has no legal basis for her objections. Nia stood perfectly still, her hands resting lightly on the table in front of her. Johnson sat down again, leaning back in his chair with a satisfied smile. He thought he'd already won. Nia took a slow breath and spoke for the first time. "Your Honor, may I respond?" 5 years ago, Nia Williams had sat in a very different courtroom. It was the state capitol building, 5th floor, with marble columns and tall windows that let in too much light. She'd been Attorney General for 2 years by then, and she was testifying before the legislature about a bill she had written herself. The Consumer Financial Protection Act. Predatory lenders, she'd said into the microphone, her voice steady and clear, target the most vulnerable people in our state. They hide fees in complex language. They charge interest on top of interest. They turn a $500 emergency into a $2,000 trap. Some of the legislators nodded. Others had looked bored. A few had been paid by the lending industry to vote no, and everyone knew it. But Nia had kept talking. "This bill," she continued, holding up a document that had taken her staff 8 months to draft, establishes a clear legal framework. It limits the total fees a lender can charge. It requires transparent disclosure. And most importantly, it gives victims the right to challenge predatory practices in court. The bill had passed by 3 votes. Nia had stood in a gallery and watched the governor sign it into law. She remembered thinking, this will protect people. This will matter. And it had. For a while. But then the lending companies found loopholes. They hired expensive lawyers. They rewrote their contracts with clever language that sounded legal but wasn't. They kept doing exactly what they'd done before, just with different words. So Nia had left her office. She'd walked away from the title and the power and the ability to change laws from the top. Because she realized something, laws only mattered if someone enforced them. And enforcement happened one case at a time. Nia blinked, pulling herself back to the present. Judge Brennan was waiting. "Yes, Counselor," he said. "You may respond." Nia picked up the contract from her table. She didn't need to look at it, she'd already memorized every word, but she wanted the judge to see what she was holding. "Your Honor," she said quietly, "Mr. Vane is correct about one thing. Contract law does allow parties to agree to terms. But those terms still have to follow the law." Johnson rolled his eyes. "That's exactly what I just." "I'm not finished," Nia said. Her voice wasn't loud, but something in her tone made Johnson stop talking. She turned to page 2 of the contract and held it up so Judge Brennan could see. "Section 4.7, she said. Buried in the middle of the second page, in 6-point font. "It's called an account liquidation and maintenance fee." Judge Brennan leaned forward slightly. "What does it say?" It says that if a borrower misses a payment, the lender can charge a fee equal to 15% of the remaining balance. And that fee is charged every single month until the loan is paid off. The judge frowned. 15%. Every month? Yes, Your Honor. In Ms. Porter's case, that fee alone has added over $900 to her debt. Johnson stood up quickly. Your Honor, that's a standard administrative cost. It's clearly outlined in the contract. It's also illegal, Nia said calmly. The courtroom went quiet. Johnson stared at her. Excuse me. Nia turned to face him directly. The Consumer Financial Protection Act, Section 302, subsection C. It explicitly prohibits lenders from charging recurring percentage-based fees on delinquent accounts. The total fees on any loan cannot exceed 25% of the original principal. She paused, letting the word settle. Ms. Porter borrowed $500. The fees on her account currently total $1,200. That's 240%. Johnson's confident smile began to fade. Judge Brennan set the contract down and rubbed his temples like he had a headache coming on. Counselor, he said, looking at Nia with the tired patience of a man who had heard 1,000 desperate arguments before. These consumer protection claims are complicated. This is a small claims court. We deal with simple breach of contract cases here. Nia opened her mouth to respond, but the judge raised his hand. I understand you're trying to help your client, he continued. But Mr. Vane's firm has been operating in this state for 15 years. They have an entire legal department. If there was a violation of the Consumer Financial Protection Act, don't you think someone would have noticed by now? Johnson stood up, sensing an opportunity. Your Honor, with respect, opposing counsel is grasping at straws. She's trying to turn a simple debt collection case into some kind of conspiracy theory. Exactly, Judge Brennan said, nodding. This court doesn't have the resources or the jurisdiction to investigate complex regulatory violations. If Ms. Porter believes the loan terms were illegal, she should file a complaint with the State Banking Commission. Your Honor, Nia began. I'm sorry, Counselor, but I'm going to have to ask you to move on. Do you have any other arguments regarding the actual contract dispute? Nia stood very still. She could feel Shanice trembling in the chair beside her. She could feel Johnson's smug satisfaction radiating from across the room. Judge Brennan was already reaching for his gavel. Unless you have something else, he said, I'm prepared to rule in favor of the plaintiff. Nia looked down at her file. Then she looked back up at the judge. Your Honor, she said quietly. I'd like to request a 15-minute recess. Brennan sighed. Fine. 15 minutes. He banged the gavel. Nia walked into the hallway with Shanice following close behind. Before she could say anything, Johnson appeared at her side, his cologne expensive and overwhelming. Can we talk? He asked, but it wasn't really a question. He gestured toward an empty corner near the water fountain. Nia nodded to Shanice to wait, then followed him. Johnson's smile was gone now. His voice was low and sharp. You're wasting everyone's time, he said. The judge is about to rule against you. Your client is going to lose. And when she does, I'm going to add every single court cost and legal fee to her debt. Do you understand what that means? Nia said nothing. It means instead of owing $2,400, she'll owe $4,000. Maybe $5,000. And I will personally make sure that debt follows her for the rest of her life. I will garnish her wages. I will put a lien on anything she owns. I will make her regret ever walking into that courtroom. He stepped closer, his voice dropping even lower. But I'm a reasonable man, he continued. So here's what I'm offering. Your client pays $1,500 today, that's a $900 discount, and we walk away. Case closed. Everybody goes home. Nia met his eyes without blinking. She doesn't have $1,500, Nia said quietly. Then she should have thought about that before she borrowed money she couldn't pay back, Johnson said. Look, I don't know what law school you went to, if you even went to law school, but let me give you some free advice. You can't win this. You're out of your depth. Take the deal and save yourself the embarrassment. He straightened his tie and checked his watch. You've got 10 minutes, he said. Think carefully. Then he walked away, leaving Nia standing alone by the water fountain. What Johnson didn't know was that Nia had recorded the entire conversation. The small device in her jacket pocket had been running since the moment they stepped into the hallway. It was perfectly legal. Georgia was a one-party consent state, which meant only one person in a conversation needed to know they were being recorded. Nia had learned that law a long time ago. She'd written part of it herself. But the recording from the hallway wasn't the only one she had. 3 days earlier, Nia had called Pinnacle Recovery Solutions from a burner phone. She'd pretended to be a landlord interested in using their services to collect unpaid rent. The sales representative had been eager to help. "We specialize in high-volume recovery," the woman had said, her voice bright and professional. "Our system is very efficient. We focus on specific zip codes where collection rates are highest." "Which zip codes?" Nia had asked. "Primarily lower-income areas. Neighborhoods with high minority populations. People in those areas are less likely to challenge us in court. Most of them don't even show up to the hearings." Nia had stayed quiet, letting the woman keep talking. "And our contracts are designed to maximize returns," the representative had continued. "We include administrative fees that compound monthly. By the time a debtor realizes what's happening, the amount owed has usually doubled or tripled." "Is that legal?" Nia had asked. The woman laughed. "Legal enough. We've been doing it for 12 years. Nobody's stopped us yet." Nia had thanked her and ended the call. Now, standing in the courthouse hallway with Shanice looking at her with worried eyes, Nia pulled out her phone and checked the recordings one more time. Both files were clear. Both were admissible. Johnson Vane had just made a terrible mistake. And he had no idea. When they returned to the courtroom, Johnson was already standing at his table with a new document in his hand. "Your Honor," he said before Nia could even sit down. "I'm filing a motion for summary judgment." Judge Brennan looked up, confused. "Right now?" "Yes, Your Honor. This case has no merit. Opposing counsel has failed to present any valid legal defense. The contract is clear. The debt is valid. There are no disputed facts. I'm asking the court to rule immediately in favor of my client and award the full amount owed, plus costs." It was a power move, designed to end the case before Nia could say another word. Judge Brennan looked uncertain. "Counselor, this is highly irregular. Summary judgment motions usually require." "I understand, Your Honor, but we're in small claims court. The rules are more flexible here. And frankly, I don't think we need to waste any more of the court's time. Opposing counsel has had her chance to present a defense. She hasn't. It's over." Johnson placed the motion on the clerk's desk with a confident flourish. Judge Brennan looked at Nia. "Counselor, do you have a response?" Nia stood slowly. She reached into her briefcase and pulled out a thin folder. Inside were 3 documents, the recordings she'd made, a copy of the Consumer Financial Protection Act with relevant sections highlighted, and a list of 47 other cases where Pinnacle Recovery Solutions had used identical contracts. "Your Honor," Nia said quietly, "before you rule, I'd like to submit evidence of systematic fraud." Johnson's head snapped toward her. "Objection. Your Honor, this is completely inappropriate. She can't just." "I'd also like to submit recorded admissions," Nia continued, "from Mr. Vane and his firm, showing intentional targeting of minority communities and deliberate violation of state consumer protection laws." The courtroom went silent. Judge Brennan stared at her. "Counselor," he said slowly. "Who are you?" Nia set the folder on the table in front of her and looked directly at Judge Brennan. "My name is Nia Williams," she said. "I served as State Attorney General from 2017 to 2023. The words hung in the air like a thunderclap. Johnson's face went pale. One of his associates in the back row actually gasped. Judge Brennan leaned forward in his chair, his eyes wide. "You're Attorney General Williams?" "Former Attorney General," Nia corrected. "I left the office 2 years ago." Brennan looked down at the cheap suit, the scuffed briefcase, the thin glasses. He looked like a man trying to solve a puzzle that didn't make sense. "But, why are you here?" he asked. "In small claims court?" "Because this is where people like Ms. Porter end up," Nia said simply. This is where predatory lenders think no one is watching. This is where they've been getting away with fraud for years. Johnson finally found his voice. Your Honor, this is ridiculous. Even if she is who she says she is, it doesn't change the facts of this case. The contract is still. The contract, Nia interrupted, her voice sharp now, violates Section 302 of the Consumer Financial Protection Act. A law I personally wrote and defended before this state's legislature in 2019. She picked up the folder and walked toward the judge's bench. Mr. Vane told you earlier that there's no provision in state law limiting administrative fees on private loans. He was wrong. Or more accurately, he was lying. Johnson stood frozen, his mouth open but no words coming out. Nia placed the folder in front of Judge Brennan. Everything you need is in here, Your Honor. The statute. The recordings. The evidence. She stepped back and waited. The courtroom was completely silent. Judge Brennan opened the folder with trembling hands. The first document was a photocopy of Nia's official Attorney General identification card, complete with the state seal and her photograph. Younger in the picture, wearing a different suit, but unmistakably her. The second document was the Consumer Financial Protection Act itself, signed into law on March 14, 2019. At the bottom of the title page, in small print, it read, Principal Author, Attorney General Nia Williams. Brennan looked up at her, then back down at the documents, then up again. I don't understand, he said quietly. Why didn't you say something? Why didn't you identify yourself at the beginning? Because I wanted to see how Mr. Vane operates, Nia said. I wanted to hear what he says when he thinks no one is listening. I wanted him to feel comfortable enough to show me exactly who he is. She turned to look at Johnson, who was now gripping the edge of his table like it was the only thing keeping him upright. And he did, Nia continued. He mocked my appearance. He questioned my education. He explained the law to me incorrectly, the same law I wrote. He threatened my client with financial destruction. And out in that hallway, he admitted on tape that his firm deliberately targets minority communities because they're less likely to fight back. Johnson's voice came out as a whisper. You recorded me? Yes, Nia said simply. Georgia is a one-party consent state. You should know that. It's basic law. She turned back to the judge. Your Honor, this isn't just about a $500 loan anymore. This is about a pattern of fraud that has destroyed families across this city. And it stops today. Judge Brennan sat back in his chair, stunned. No one in the courtroom moved. The bailiff stood frozen by the door, his hand still resting on his belt. The court clerk had stopped typing mid-sentence. Johnson's two associates sat in the back row with their mouths hanging open, their expensive tablets forgotten in their laps. Even Shanice, sitting beside Nia, stared at her lawyer like she was seeing her for the first time. Judge Brennan took off his glasses and cleaned them slowly, a nervous habit he'd had for 30 years. He put them back on and looked at Nia again, as if checking to make sure she was real. I remember when you testified about this law, he said quietly. I watched it on the news. You said predatory lenders were destroying families, and that the courts had a responsibility to protect people, not corporations. I still believe that, Nia said. Brennan nodded slowly. He looked down at the folder again, then at Johnson, who had gone from pale to gray. One of the associates in the back row stood up suddenly and walked out of the courtroom. The door closed behind him with a soft click that sounded impossibly loud in the silence. Johnson tried to speak. His mouth moved, but nothing came out at first. When he finally found his voice, it was thin and shaky. Your Honor, we didn't know. If we had known who she was. You would have done exactly the same thing, Nia said, cutting him off. You've been doing this for years. The only difference is that today, someone finally had the power to stop you. She turned back to Judge Brennan. Your Honor, I'd like to play the recordings now. And then I'd like to present evidence of 47 identical cases involving this firm. Brennan picked up his gavel, then set it down again. Proceed, he said. Nia connected her phone to the courtroom speaker system. The clerk helped her, hands still shaking slightly. The first recording played. Johnson's voice filled the room, clear and unmistakable. It means instead of owing $2,400, she'll owe $4,000. Maybe $5,000. And I will personally make sure that debt follows her for the rest of her life. Johnson closed his eyes. The second recording played. The sales representative from Pinnacle Recovery Solutions, bright and cheerful, explaining their strategy. We focus on specific zip codes where collection rates are highest. Primarily lower-income areas. Neighborhoods with high minority populations. People in those areas are less likely to challenge us in court. When the recording ended, the silence was deafening. Nia picked up the Consumer Financial Protection Act and held it so everyone could see. Section 302, subsection C, she said, her voice steady and clear. No lender may charge recurring fees that exceed 25% of the original loan principal. Violation of this statute constitutes fraud and subjects the lender to civil penalties, criminal investigation, and mandatory restitution. She turned to a marked page. Section 305, subsection A. Any lender found to have engaged in discriminatory targeting based on race, income, or geographic location shall have their business license suspended and shall be subject to federal civil rights investigation. She closed the book and set it on the table. Mr. Vane's contract violates Section 302. His firm's business practices violate Section 305. And his personal conduct in this courtroom, threatening a client with financial destruction, attempting to intimidate counsel, filing a frivolous motion to prevent evidence from being heard, violates the state bar's rules of professional conduct. Nia looked directly at Johnson. You didn't just break the law, she said quietly. You broke the law I wrote specifically to stop people like you. Nia reached into her briefcase and pulled out another document. This one was thicker, bound with a black clip, pages marked with colored tabs. Your Honor, she said, I'm formally moving for sanctions against Mr. Vane personally and against Pinnacle Recovery Solutions as a corporate entity, under Rule 11 of the Georgia Civil Practice Act. Judge Brennan nodded slowly. On what grounds? Fraud, bad faith litigation, and knowing violation of consumer protection statutes, Nia said. Mr. Vane filed a frivolous motion for summary judgment despite having actual knowledge that his client's contract was illegal. He threatened my client with financial ruin to prevent her from exercising her legal rights. And he presented false information to this court when he claimed there were no state laws limiting loan fees. She placed the document on the clerk's desk. I'm also requesting that this court refer Mr. Vane to the state bar for disciplinary proceedings, and that Pinnacle Recovery Solutions be referred to the state attorney general's office for criminal investigation. Johnson finally stood, his legs unsteady. Your Honor, please. We made a mistake. We'll withdraw the case. We'll forgive Ms. Porter's debt. You'll be quiet, Judge Brennan said, his voice harder than it had been all day. Johnson sat down. Brennan looked at Nia. What else do you need from this court? I need you to void the contract entirely, Nia said. I need you to order Pinnacle Recovery Solutions to return every payment Ms. Porter has made, $740. And I need you to issue a preliminary injunction preventing them from collecting on any similar contracts until a full investigation can be completed. She paused. There are 47 other families, Your Honor. They all deserve justice too. Brennan picked up his gavel. Granted, he said. The courtroom doors opened. 3 people in dark suits entered, each carrying a leather folio and a badge clipped to their belts. The lead investigator, a tall woman with gray hair pulled back in a tight bun, walked directly to Judge Brennan's bench. Your Honor, she said, I'm Senior Investigator Patricia Cole with the State Attorney General's Office, Financial Crimes Division. We've been monitoring this case remotely per a request filed by Ms. Williams 3 days ago. Johnson's head snapped toward Nia. His eyes were wide with something close to panic. Investigator Cole continued. Based on the evidence presented here today, we have obtained an emergency warrant to seize all electronic records, servers, and client files from Pinnacle Recovery Solutions. We also have a warrant to freeze the company's assets pending a full criminal investigation. She handed a document to the bailiff, who brought it to the judge. Judge Brennan read it quickly and nodded. The warrant is valid. Cole turned to face Johnson. Mr. Vane, you are required to provide immediate access to your firm's offices and servers. Any attempt to delete, modify, or hide records will result in additional criminal charges. Do you understand? Johnson didn't answer. He just stared at her like a man watching his entire world collapse. One of the other investigators approached Johnson's table and held out a tablet. "We need the address of your main office and the login credentials for your case management system." Johnson looked at Nia. For the first time all day, there was no arrogance in his expression. No mockery. No confidence. Just fear. "You planned this," he said quietly. "You planned all of this." Nia met his eyes without blinking. "Yes," she said. "I did." The investigators waited. Johnson, hands shaking, began typing on the tablet. Judge Brennan stood, something he rarely did in small claims court. "Mr. Vane," he said, his voice carrying a weight it hadn't had before. "I've been a judge for 23 years. I've seen lawyers make mistakes. I've seen lawyers lose their temper. I've even seen lawyers bend the rules a little too far." He paused, looking directly at Johnson. "But I have never seen a lawyer deliberately weaponize the law to destroy vulnerable people. I have never seen someone stand in my courtroom and threaten financial ruin against a single mother who borrowed $500 to fix her car." Johnson opened his mouth, but Brennan raised his hand. "I'm not finished. Based on the evidence presented here today, and the authority granted to me under Section 419 of the State Judiciary Code, I am issuing the following orders." He picked up a pen and began writing. "First, I am referring you to the State Bar with a recommendation for immediate disbarment. Second, I am ordering you to personally repay every dollar in bonuses, commissions, and profit-sharing payments you received from Pinnacle Recovery Solutions over the past 5 years, pending verification that those earnings were derived from fraudulent contracts." Investigator Cole stepped forward and handed the judge another document. "According to our preliminary review, Your Honor, Mr. Vane's fraud-linked compensation totals approximately $2.3 million. The number hung in the air. Johnson's face had gone from gray to white. He gripped the table in front of him, his knuckles bone pale. $2.3 million, Judge Brennan repeated. To be placed in a court-supervised restitution fund for victims. If you fail to comply, you will face criminal charges for fraud, racketeering, and conspiracy. Brennan set down his pen. "Do you understand these orders, Mr. Vane?" Johnson nodded weakly, unable to speak. Investigator Cole stepped forward again, holding a tablet that displayed rows of data. "Your Honor," she said, "our forensic accountants have been reviewing Pinnacle Recovery Solutions records for the past 72 hours. We've identified 218 active cases using contracts identical to Ms. Porter's. Another 463 cases were closed within the past 3 years using the same illegal fee structure." Judge Brennan looked stunned. 681 cases. "Yes, Your Honor. Collectively, these victims have paid approximately $19.2 million in fees that violate state law. When we add statutory penalties and punitive damages, the total restitution amount comes to $27.4 million. The number echoed through the courtroom. Johnson made a sound, something between a gasp and a sob. Cole continued. Pinnacle Recovery Solutions has agreed to a consent decree. They will establish a court-supervised restitution fund, surrender their business license, and cooperate fully with ongoing criminal investigations. Any officer or employee found to have knowingly participated in the fraudulent scheme will face individual charges." She turned to look at Johnson. "That includes you, Mr. Vane." Judge Brennan picked up his gavel and held it for a moment, as if weighing the significance of what he was about to do. "This court orders the immediate establishment of a restitution fund in the amount of $27.4 million, he said. Every victim identified in the state's investigation will be notified and given the opportunity to file a claim. This fund will be administered by the State Attorney General's office." He looked at Nia. "Ms. Williams, I assume you'll be coordinating victim outreach?" Nia nodded. "I will, Your Honor." Brennan brought the gavel down with a sharp crack that seemed to split the room in two. "Court is adjourned." Nia walked down the courthouse steps the same way she'd walked up them that morning, quietly, with her scuffed briefcase in one hand and her thin glasses reflecting the afternoon sun. Shanice followed close behind, tears streaming down her face. She kept trying to say thank you, but the words came out broken and choked. "You don't have to thank me," Nia said gently. "This is what the law is supposed to do." "But you gave up everything," Shanice said. You were the Attorney General. You could have stayed in that office. You could have. I could have kept making speeches, Nia said. I could have kept writing laws that nobody enforced. But laws don't protect people. People protect people. She stopped at the bottom of the steps and turned to face Shanice. You're going to get your money back. All of it. And you're not going to be evicted. Your daughter is going to start first grade in 3 weeks, just like you planned. Shanice hugged her, and Nia let her. When they separated, Nia reached into her briefcase and pulled out a folder. A new one. There's a man in Dalton, she said. He took out a car title loan. Same company, different name. He's about to lose everything. I'm meeting with him on Tuesday. Shanice looked at the folder, then at Nia's $15 suit, then at the woman who had just destroyed a multimillion-dollar corporation without raising her voice. How many more? Shanice asked. Nia smiled, just a little. As many as it takes. She walked toward the parking lot, her cheap suit hanging loose on her shoulders, already reading the next case file. Behind her, the courthouse doors closed with a quiet click. Justice wasn't charity. It was work. And Nia Williams had plenty of work to do. Was the punishment enough, or should it have gone further? How many more cases like this do you think are happening right now? Tell me in the comments, was justice served?